Bello. Hey, oh, kacau lagi. Sini. Ya, bello. Gol. Oh. Ya. Ya.
So, for case 1, I will talk about the case of Bursa Malaysia Security Berhad v Muhammad Afrizan bin Hussein. First, Wintoni is an East Market Publicity listed company that was overseen by Bursa. Then, Wintoni was ordered winding up on August 17, 2017, but Bursa did not remove Wintoni after the court designated Muhammad Afrizan as a liquidator. Then, Bursa agreed to follow the ACE Market Listing Requirement, ACELR, on 20 September 2017. Then, on the 31 October 2017, the liquidator issued a statement that the liquidation were not assembled in Wintoni financial account. Then, Bursa investigate Wintoni in March 2018 for delay announcement and financial reporting. Then the liquidator said it was his duty, but Wintoni couldn't create the financial account because the firm are closed. After that, Bursa started ACE LR enforcement against the liquidator and others. Also, Bursa notified the liquidator on May 6 and instruct him to cooperate with or pass the responsibility to Wintoni board to ensure that the financial results are announced within 3 months. Then the liquidator challenged this finding in High Court. Separately, in September 2019, Wintoni contributories got an insolvency order. The High Court allowed the liquidator judicial review request, and the reasons were as follows. 1. The obligation provided financial statement is not one of the liquidator responsibility under the CA 2016. Instead, the board of directors of Wintoni are in charge. Second, the effort violates CA 2016 and is invalid because it is illegal. The last one is when Wintoni delisted, Bursa Malaysia had no choice but to delist it. That's all from me. Thank you.
Two things that Federal Court consider for this case. Bursa retains the discretion on timing of delisting of one out company, and the liquidator has an express duty to ensure compliance with the listing requirement. So, there is statutory and contractual relationship between Bursa and the listed company, between Bursa and the person in control of the listed company. The person having control of the listed company is contractually bound by Bursa's regulation. Then, the court dealt extensively whether the word shall, in the context of Bursa duty to delist one out company under Rule 16.11 subsection 2 of the East Market Listing requirement was mandatory or only directory. The court held that the word shall should be construed in the context of the entirety of Rule 16.11 subsection 2, the AMLR, and the Capital Market and Service Act 2007 the broader statutory context, include the primary function of Bursa to act in the public interest to protect investors. Furthermore, an immediate delisting may cause irreparable damage to investor. For instance, if the winding up order is then reversed and appeal or stay, the delisting would have already occurred and with no opportunity to reverse this. In conclusion, the Federal Court stated that Bursa may delist the listed corporation after taking into consideration the relevant interests as outlined in the CMSA and AMLR at an appropriate time and not immediately upon pronouncement of the winding up order. Next, the Federal Court clarified that there is an express duty on the part of a liquidator of a listed corporation to comply with the AMLR as the main listing requirement as the case may be, as long as the one-out company remain listed. In this case, the liquidator had signed the letter of undertaking to comply with AMLR, but the Federal Court ground appear to also hold that besides the letter of undertaking, there is such an express duty to comply with AMLR or the main listing requirement. The Federal Court referred to Section 480 of Company Act 2016 and it states, where a person other than the official receiver is the liquidator in a winding up of a company by court, the official receiver shall take cognizance of his conduct, and if the liquidator does not faithfully perform his duty and duly observe all the requirements imposed on him by any written law or otherwise with respect to the performance of his duty. In conclusion, the court held that it is the legal obligation of the liquidator to procure the directors to make the requisite disclosure in compliance with the AMLR where the liquidator is unable to do so personally or has no relevant knowledge. So that's all from me. Thank you.
In conclusion, to be a good liquidator, one must understand his obligations. The liquidator must follow the Company Act 2016 and Bursa Malaysia's listing requirements. Since the company is winding down, the liquidator maintain control. The liquidator must submit documents to Bursa Malaysia to delist the listed company. The director must provide the liquidator with the listing document. If not, Bursa Malaysia cannot delist the company without the requirement document.
The second case is related to the subtopic in Chapter 12, which is Judicial Management. The case that I will refer for this topic is Komi Group Berhad case, which focus on the issue relating to the listed companies and judicial management. Before that, what is judicial management? Judicial management is one of the Malaysia's corporate rescue mechanism where a company is insolvent or near insolvent. A judicial management order will place the distressed company under the control of the court-appointed judicial manager. And then the judicial manager will have to present a statement of proposal to the company's creditor in an attempt to restructure the company's debt. The issue that arises from this case is Komi Group Berhad filed for judicial management on 14 April 2021, where Komi Group Berhad is a listed company under Capital Market and Services Act 2007. According to the Section 403, subsection B in the Companies Act 2016, judicial management provision does not apply to the company that is subject to the Capital Market and Services Act 2007, whose shares are quoted on a stock market of a stock exchange, which is Komi Group Berhad fall under. The second issue is Komi does have a secure creditor. According to the Section 409, subsection B in the Companies Act 2016, the court shall dismiss the application for a judicial management order if it is satisfied that the making of the order is opposed by a secure creditor, which means any secure creditor can exercise a vote against the judicial management application. Hence, we will have to see if such a vote is exercised in this case. So, let's hear the solution from the next presenter for this case.
Thank you, Husna, for sharing the issues in Komi Group Judicial Management application. So I will explain the High Court's decision. Komi Group Berhad's appeal against the High Court's decision dismissing its judicial management application was denied by the Court of Appeal. When dismissing the judicial management application of Komi Group Berhad, a listed company, the High Court ruled on 2 points. The High Court first ruled that a listed company could not apply judicial management. The High Court concluded that a listed company will be covered by the Company Act 2016 Section 403B exclusion, a corporation subject to a Capital Markets and Services Act 2007. For the second issue, yes, a secured creditor had exercised his veto right under Section 409 of the Company Act 2016. To oppose the judicial management application. In the near future, Malaysia restructuring and insolvency law will be amended. One of the change will be to replace the board wording in the Company Act 2016, Section 403B, with the more focus referring to more specific licensed entities. The policy change aimed to make it possible for listed company to apply for judicial management in general. So that's all from me. Thank you.
In conclusion, before the company decide want to apply the judicial management, the company need to refer Company Act 2016 that if the company is under the Capital Market and Service Act 2007 and the company is a licensed institution of a designated payment system under the law by the Central Bank of the Malaysia, so the company cannot apply the judicial management. Overall, from this both case, we learn that everyone that related to the company have their own responsibility that need to be carried out. Next, we also learn a lot about how to apply Company Act 2016 in the decision that the High Court made from the issues of the case. This shows us how important the Company Act 2016 to solve a problem of the issues. So, that's all from us. Thank you.